Right, it's 12:02, so we're going to go ahead and get started. Good afternoon, and welcome to today's webinar, Pre-Winter Break Check-In, Disability Issues to Anticipate in the Spring Semester, hosted by us here at Saul Ewing. Next slide, please. My name is Jessie Crone, and I'm an associate in our higher education practice based in Philadelphia. I'm joined today by my colleague, Jennifer Robbins, who is a counsel in our Washington, D.C. office. Our contact details are available in the Resources tab at the bottom of your screen. Next slide, please. Before we begin, just a few quick notes. In terms of questions, to submit questions, please use the Q&A tool. We will try to answer as many as possible today, but we can follow up by email if time runs short. In terms of credit, this program is approved for HRCI and SHRM credit and is eligible for one distance learning substantive CLE credit in several states. To receive credit, complete the verification survey that is linked in the Resources tab and enter the numeric codes announced during today's session. Please submit the survey by Thursday, December 18th. You will receive a follow-up email from our team in the coming days with the webinar recording, slides, and credit information. And then finally, because we could not be complete without it, a disclaimer. The provision and receipt of information in this program is not legal advice. It does not create a lawyer-client relationship, and it should not be acted on without seeking professional counsel who have been informed of the specific facts. So our goal for today is to offer a very practical approach to some common legal issues, but we know these cases are very nuanced, so we want to make sure that we think of them not just as one size fits all, but really as individual and unique situations. Next slide, please. So what will we be talking about today, and where did we get the idea for this webinar? So we know that right now we're in December, faculty are heading home, students are heading home, but attorneys and human resources professionals and compliance professionals are still hard at work. You're going to have to explain to your families yet again at Christmas dinner or Hanukkah or Kwanzaa that you actually don't have a month and a half off in the winter or the summer, much to your dismay. So what would you be looking for to get ready for the next term? We put some thought into that and decided that what we wanted to offer was a series of high-level touch points on some common spring semester disability-related issues to refresh your knowledge, to teach you something new, and then also give you some ideas for kicking the tires on various issues in anticipation of the next term. Next slide, please. The laws that we're going to be talking about today are the Americans with Disabilities Act. So we know Title II, which is applicable to public institutions, and Title III, which is applicable to private institutions. We'll also talk about Section 504 of the Rehabilitation Act and the Fair Housing Act, but we will mostly be using those terms interchangeably because the obligations under each are really very analogous. And now I'm going to go ahead and turn this over to Jen to start our conversation with our first topic, which is study abroad.
Well, thank you, Jessie, and thank you all for joining us during this very busy time of the season. Jessie just gave that overview of what laws apply, and we're diving here into study abroad. You may have students about to start their study abroad programs, and also in the coming semester likely have students that are going to embark on looking for a study abroad for the following semester. So this is one of those topics we wanted to address. Next slide, please. And you've already made it to your first credit code, which is 64732. Again, credit code 64732. So we went over the laws that apply, but we're jumping right into somewhere where it already gets murky, because we're talking about study abroad programs that are overseas, international. So does the law even apply? You might remember back from like your basic international law classes that there is a presumption against extraterritorial coverage, but that doesn't mean that we should just throw our ADA obligations to the side. While the ADA is silent on extraterritorial coverage, when it has come up before courts and OCR or the Office of Civil Rights, they have tended to skip right over that issue and go right to the merits. So there's a district court opinion that tackled the question and found that the ADA did apply to the Colleges Study Abroad program in Australia. In doing so, it emphasized that the plaintiff was an American student participating in an American university's overseas program taught by American faculty. So as you can see, to the extent there is analysis done, it's probably going to turn in some way on the nexus or connection or involvement of the home university. But at the end of the day, courts and OCR have skirted the issue. OCR had a decision that came out the other way. And so given the uncertainty in the space, it seems wise to proceed as if disability discrimination laws apply to study abroad programs. Next slide, please. So then what should we do about it? What laws are we worried about? What are our basic principles? Just to set the floor. Obviously, students with disabilities can't be generally rejected from programs because of their disability. You're going to look at your regular analysis. Access should only be denied where the accommodation would constitute a fundamental alteration or the student's participation would constitute a direct threat to safety. And the guiding question is going to be whether the student is able to enjoy the benefits offered by the program. You're going to be looking at meaningful access to the program as a whole. I threw up a couple of cases where this has come up that kind of go to that heart of the issue, that study abroad is a meaningful program and that students' access to it is judged by access to the program as a whole. In that Ninth Circuit case, the plaintiff was an undergraduate student who used a wheelchair. During her study abroad program, the home university accommodated her disability in many ways and made many of the activities accessible. But there were also times when there were stairs involved, places she couldn't access. She would be carried. She had students basically assigned to assist her. And in that case, the court denied the ADA claim. It found that most relevant, the university had accommodated her in a number of ways, and the plaintiff had enjoyed many benefits of the program. So they didn't look just at whether the specific places where her accommodation wasn't able to be granted, but they looked at the program as a whole and the accommodations as a whole. Next slide, please. All right, so that's our underlying principle. Let's talk practical tips for those of you on the ground really dealing with this day to day. You want to start by making disability and accommodation requests part of your study abroad overview. So whether that's your orientation, your materials that are out in your study abroad office, is it your website? There should be content about disability services and reasonable accommodation requests from the jump. That's going to lead right into the next point, which is encouraging students to applying to study abroad to put in reasonable accommodation requests early. So if you've opened up the conversation by having those out in your materials, you can get those requests early and start dealing with them. Another point is to ensure that your disability services office and your study abroad office, which may be, in different buildings, probably have no crossover staff, maybe aren't even at the same, functions and group meetings, that there's lines of communication open between those two offices. It's very possible that a student walks into the study abroad office and talks about some of their accommodation needs, but it never makes its way over to the disability service office who is best equipped to address it. So you want to have open lines of communication between those offices. You're also going to want to strive to have programs, informational materials include the essential program requirements. That's going to help you all as you consider reasonable accommodation requests and what is ultimately a fundamental alteration of the program. Finally, after a student has been admitted, staff can make those confidential inquiries to determine whether they may need an accommodation. But again, the earlier you open the door, you encourage those conversations, the sooner you can start and hopefully avoid issues that have the potential to come up. Next slide, please. All right, we're gonna have a hypothetical here. Maybe it will sound in some truth for those of you in these spaces. Sarah wants to study abroad in a specific city. Her college doesn't have any programs in that city, but it does permit students to enroll in other institutions' programs and accepts the academic credits earned there. So Sarah goes out, she does her research, she locates a program through a school in her desired city, and with her college's approval, she enrolls. When she gets there, she's shocked to learn that the academic accommodation on which she relies and had access to at her home university, including extended time testing, aren't permitted. Now she's calling up her academic advisor and demanding that her college do something. Okay, so this is why we're trying to avoid these issues and having some proactive opening of conversations. But here we are, she's already there and run into this issue. So a couple things to think about in whether this request is reasonable. it comes back to that control issue and what part of the program is under the university's control. And it also comes down to the program and where it is situated. So a given country may have laws, customs, lack of resources, or other challenges that are going to factor into the reasonable analysis. In this case, it may not be customary or familiar to offer students extra time. And those factors are going to impact the analysis of what constitutes a reasonable accommodation. Now, let's say, though, this was the college's own program, not one that Sarah went and found on her own. Maybe a program even where there's an agreement or a memorandum of understanding. That's going to change the analysis, right? Because now maybe it's faculty led. Now the home university has more control over the process and what is reasonable to provide, and those factors such as custom and resources in another institution won't be as applicable. So I want to offer up one other twist. Here we're talking about testing accommodations and extended time. But what if this were a request for a sign language interpreter? And I'm going to ask Jessie what she thinks about the hypothetical in that twist.
So when you change the nature of the requested accommodation to something that doesn't impose necessarily an inconvenience or burden on the foreign institution, that is just one of the factors that you want to consider in what, if anything, your institution is able to provide to the student. So we had a question show up in the Q&A. What do we do when this arises, when the student is already abroad? That's exactly the kind of scenario we're talking about here, is having those open lines of communication, having plans in advance for how we will be able to respond to requests as they arise. We don't want you to leave the webinar saying, Saul Ewing told us we have to pay for sign language interpreters and wheelchair ramps at foreign institutions. That's like not a thing that we're saying. But you want to consider all options that are on the table. So if the student may be able to be accommodated, if she had access to a device or to a software program that is available to her when she is enrolled at the home institution, is it possible that you can make that available to her while she is studying abroad, even if if that is something that you could do with like a limited cost or burden? You could also consider options that could enable Sarah, for example, to return. If this program is not one that is accessible to her, she maybe regrets having chosen it. Could you waive late registration fees or deadlines in order to enable her to re-enroll for the semester? Could you waive a requirement that she have certain courses done in a sequence in order to enable her to rejoin her program? Waive a requirement for her to reside on campus because now there's no availability for her to return to her residential facility. So what is it that you could do in order to help the student to regain her academic momentum? So thinking holistically is really the place we want to start.
And I think, Jessie, that leads right into clinics, maybe a cousin of study abroad.
Yes, I agree. The next slide, please. So again, just like study abroad, experiential learning is something that may prop up, especially for first year students during the spring term. They may have started their experience either as undergraduates or master's students in the fall with didactic or classroom instruction, and then be moving into student teaching or a clinical experience. And that may be through a third-party partner over which the institution has no direct control. Next slide, please. What law applies? Right, so I have the full citation on the slide. It's available to you so you can read, but what does it really mean? If there's an education program or activity that students are required to participate in, and it is not under the specific control of the home institution, then the home institution must ensure that the required program or activity provides as a whole, right? So I'm mirroring the same language that Jen raised earlier with respect to study abroad, equal opportunity to students with disabilities. So on a practical level, what does that look like? Next slide, please. Institutions cannot simply abandon to external sites the institution's responsibility for accommodating students. Typically, what we see is the institution working with the third-party partner to ensure that students are able to participate. We want to see students taking the step to connect with the host institution or the clinical site or the school site or whatever the third party is. That's typical. It's also developmentally appropriate, right? We're teaching students to be self-advocates. We're teaching students to be independent. We are preparing them to navigate the workforce, as adults and professionals. But there are limits to that. So, for example, if the site where the student was assigned blanket rejects accommodation requests. It says, like, we have no duty to accommodate you. You're not a full-time employee. There's nothing that we're going to offer. We don't just end the conversation there and say, like, too bad, so sad, student, this is not an opportunity for you. This is particularly the case if there's some sort of a formal affiliation between the school and the third party. So if it's a clinical affiliation agreement, a school district agreement for student teachers, there should be some sort of non-discrimination language that talks about what the institutions, like the respective parties, have to do in order to ensure that students are accommodated. If there is no formal affiliation, this can get a little stickier. So if there's the ability for students to choose or to be assigned, having students that you know have particular high needs work with institutions that you do have a good relationship with, that you've worked with successfully to accommodate students in the back is a great preventative measure. So you don't want to limit students' choice or give them a different experience than others, but all other options being equal, certainly having a institution that you trust, that you know, and that you have a written formal agreement with can be beneficial. This may also be an impetus for you if you're sitting there thinking, well, we have that for clinicals, but not for our co-op program or our mandatory internship credit program. That may be something you want to consider. So in order to participate in your mandatory internship program, does there have to be an internship agreement with the host site? Not necessarily something overly complex and overly lawyered, but just acknowledging what their basic obligations are, to explain that they understand what the purpose of hosting a student for internship, for an internship for academic credit consists of, and to just be very clear about understandings before the internship starts. It's also a way for you to identify sites that are probably not going to be appropriate for students, right? If from the get they're not really interested in agreeing to those general principles, then you may be saving yourself and the student from trouble with an unsuitable partner going forward. So if you haven't looked at your internship agreements or your clinical affiliation agreements in a while to think, like, what do they say about disability accommodation? This is a great time to pull them out, dust them off, and make sure that they do meet your needs. In the interest of just sort of raising numerous hot issues at once, we know that Title IX and Title VI compliance with third-party partners is a current very hot topic as well, particularly in terms of like regulatory compliance and enforcement. So while you're at it, maybe take a look at your non-discrimination language more generally and whether or not you have any problematic third-party partners that you want to take a look at now. Next slide, please. We want to create opportunities for early disclosure. So this is the same thing that Jen said previously, and scaffold that throughout the student's experience as part of orientation, as part of advising. As they prepare for transitions, we're raising this issue again. Educating students about the distinction between didactic and experiential components of their programs, because this may be something that they simply aren't familiar with or may not even have considered. So if you think about a traditional sort of non-clinical student experience, we know that students oftentimes have a hard time understanding how accommodations may vary between a lab course and a lecture course or a discussion course. When you're talking about leaving the school environment entirely, like, that's a whole new conversation and an opportunity to educate students that they may need to understand. Extended time is sort of a prototypical example. A student may be very accustomed to having extended time in a lab, on exams. Extended time may not be a thing that's appropriate in a clinical environment where a student is, for example, performing a procedure. And if the student doesn't timely perform the procedure, it can introduce patient care risk or pain, or other things that really sort of emphasize the timely nature of the duties that need to be addressed. You should have regularly review and reinforce rigorous non-discriminatory technical standards that clarify what a student is expected to do. Technical standards, if there is one issue that institutions, in my experience, really could focus more attention on, that's what it is. It's the technical standards. So if you need an action item to leave today's webinar, we've already given you a couple. Here's another. Take a look at your technical standards. If your response to this question is, I don't actually know if we have programs that have published technical standards, that's where you're going to start, right? Figure out what those programs are. If they don't have standards, we're writing them. If they do, we're revising them. If your answer is a little bit more advanced, you say, well, we take a look at these at the beginning of every academic year. Then maybe what you're looking at is, well, when was the last time that I trained clinical faculty and staff about what these mean and how to talk about them? When was the last time I reviewed our web materials or our admissions materials to make sure that we were being clear with students? So, you want to start where you are and just try to move up a level every time. So, when I say what a student is expected to do, I'm comparing that to what a student is expected to be. And that's sort of the essence of what makes a technical standard compliant or not. Next slide, please. So the internet is awash with non-compliant technical standards. They come up all the time. I oftentimes will tell clients that borrowing a policy or a process or a procedure from a peer or comparator institution is a great place to start. With technical standards, I actually recommend exercising substantial caution because there are so many non-compliant exemplars that are publicly available. So if you see things that talk about what a student's sort of lack of disability status must be, like student must have full use of all limbs, student must not be hearing impaired, that should be like a clear signifier to you that the student is being held to a technical standard that is discriminatory in nature. So what we want to be looking at for technical standards is what does the student have to do? What is the actual task the student must complete or perform? So if the department says a student must have full use of all limbs and you ask why, and they say because this is a nursing student and nurses must be able to administer CPR, then the technical standard is that you must be able to administer CPR or life-saving procedures. The same thing with unimpaired hearing. If this is a student teacher and they say, well, how can you be in charge of a classroom if you can't hear that students are in distress? Well, then the technical standard is the ability to control a classroom of students, identify students in need, and administer assistance. Mentally and emotional stable, I see come up a lot. That sometimes is disguised not within technical standards, but within like handbook language about professionalism. You might see that come up. And that can be discriminatory as well. So what we're thinking is if the idea is they have to be providing professional and appropriate patient care, then that's the standard, not the student's mental stability, but the ability to provide appropriate professional and caring manner for their patient care or their student care. Next slide, please. We can talk about a couple of hypotheticals. This one is about a student named Tony. Tony enrolls in his school's pharmacy program, which requires two clinical experience practicum classes, one at a community pharmacy and one in a hospital setting. The college has clinical training agreements with various facilities, and at the end of his first day at the pharmacy site, a supervisor tells the college that Tony cannot return because of his obvious, quote, health problems. The college places Tony at a psychiatric hospital that does not offer experience in several required critical elements, and Tony objects. He raises his concerns. How should Tony's college respond? Next slide, please. I fooled you. It's not a hypothetical. It's a real thing that happened. This was the subject of an OCR resolution letter from November of 2015. And what the school found is that the complainant, who I've called Tony because it's cool and friendly, was put at a disadvantage. He was not given an equal access to the educational program because the clinical site where he was placed would not accommodate him. They found that the college did not push back at all on the hospital's assertion that they couldn't accommodate Tony. They didn't ask what his needs were, why they couldn't accommodate him, if there were accommodations that they could provide. They just moved him without providing sort of any pushback at all on the site. And then finally, the placement that was ultimately identified for the student was not comparable to the placements that were provided to his non-disabled peers. So in those situations, what we need to be thinking about is every option that may be available. Is there any way for the student to get those other critical components through an independent study? Could we extend the timeline for completion? If the student is going to be extended an additional term because of the delay, could we waive fees or costs in order to make that less burdensome? So again, paralleling what we discussed in the study abroad section, what we're really doing is thinking creatively, and what is it that we can do to make this clinical experiential learning experience available to all students, regardless of disability status. We're actually going to go ahead and skip our next hypothetical to remain on time, but it will be in the published materials that you have, including the tips from OCR. So we're moving right on to our next slide about housing change requests, and I'm going to turn things back over to Jen.
Well, thank you, Jesse, and thank you to those putting questions in the chat. We appreciate it, and we'll try to get to what we can. So housing change requests and housing accommodations, again, an evergreen issue, but one that is all the more complicated when it comes mid-year and housing assignments have already been set. Next slide, please. So here's a place where I do want to dive into a little bit of this of specific law, although they're generally, coextensive, because the Rehab Act has some regulations that speak directly to housing, and I wanted to emphasize those. So under the Rehab Act, which again applies to institutions receiving federal funding, those institutions have to provide comparable, convenient, and accessible housing to students with disabilities at the same cost as to others. So no extra charges, and similar housing options. Second, provide that such housing shall be available in sufficient quantity and variety so that the scope of students' choice of living accommodations is, as a whole, comparable to that of students without disabilities. So again, that theme as a whole, we're looking holistically, but also these students need access to comparable options, comparable variety. And then, of course, under the Fair Housing Act, which we just emphasize here because we are in the land of housing, institutions have to refrain from discrimination and provide reasonable accommodations. Next slide, please. This should also sound familiar, but to call out some language and different terms of art, accommodations must be necessary to afford a person with a disability equal opportunity to use and enjoy a dwelling unit, including public and common use areas. So no, we're not just talking about their room, right? We are also talking about perhaps the study room on that floor, maybe the what other kitchen on that floor, other places of public use within the dorm or housing space, and that the accommodations have to be feasible and practical under the circumstances. Another way of saying reasonable. Next slide, please. A couple practical tips. If at all possible, keep a reserve. I bet those of you in this space are very familiar with what accommodation requests in housing are frequently asked for. Single rooms, kitchens. Those probably come up a lot, and you know what those issues are. So, if at all possible, keep a reserve. And that's a wise thing to do that you may already be doing to account for transfer students or students returning from study abroad. Speaking of those students, and a little bit related to a question in the chat, this is another opportunity where you are going to want to provide information and encourage students to request those accommodations as early as possible. For example, students returning from study abroad, they'll probably know when they're coming back from study abroad the moment they're admitted to that program and have the dates set. So that conversation can start then. It doesn't have to be the week before they return to campus and start thinking about housing. Next slide, please. So we are talking about, and I think I put this in the chat, and Jesse gave some great examples of how we can think creatively about requests, because a student under the ADA or any of these laws is not necessarily entitled to their preferred accommodation. They are entitled to a reasonable accommodation that is appropriate to their disability. So we wanted to go through a couple of these to encourage that thinking exercise of what else may be available to offer. So you have a request for a single room. What's underlying that request? Does that student need quiet, a lack of distraction? Does it have to do with the interaction with the specific roommate at issue during that first semester? Um, some alternatives. Maybe it's enough to provide a room on a quiet floor, have extended quiet hours on a hall. Maybe what needs to be done is a priority reservation for a study carrel if they need more quiet, distraction-free space. Rooms away from elevators and common space. If it's a roommate issue, maybe the Disability Services Office can be involved in a roommate agreement and facilitating ways in which those roommates can better interact or interact in a way that is conducive to the person with the disability. Moving to the second one, an accessible unit in a specific building. I feel like you all probably know there's that one dorm that everybody wants. You're flooded with special requests for that dorm. It's such a pain. It's easy to throw up your hands and be like, no, there's no space in that dorm. But we need to all like take a deep breath and think about what else could be offered rather than a blanket no. You're going to look for accessible units in comparable buildings. And instead of a blanket no, can offer that student, here's 3 dorms that are in the same part of campus. They are also near the theater program, or they also have dining halls, or whatever feature may be making that dorm particularly popular or desirable. Request for a private kitchen. Again, maybe that supply doesn't exist. What else can you do? For example, release the student from a housing contract or make an exemption or offer accommodations within the on-campus dining program. One to think about that brings a couple of these issues together is, for example, a student with allergies requested a dorm with a kitchen. The Disability Services Office obliges. They grant the accommodation, but it took the form of a four-room unit with a shared kitchen. The student's now concerned that her roommates will cause cross-contamination in the kitchen. And so, Jesse, what are some things that the university could think about doing, having already granted the accommodation, but now the student's coming back with new concerns?
Again, we want to think creatively, and dining related issues, particularly related to gluten, and other common allergens, we've seen a major increase, both in requests and also regulatory activity related to these and litigation. So it could be assistance developing a roommate agreement, right? So helping to address the students' concerns by sort of remonstrating with their roommates, or providing training for the roommates about cross-contamination. It could be providing a locked drawer or cabinet for the student to keep foods in, or providing for the student to have permission to have a refrigerator and microwave that is limited to their private living area. Again, it could be, as we sort of said in the slide, releasing a student from a commitment to live on campus that they had provided, or steering the student towards options that may be available through on-campus dining. But again, the preference of the student is not necessarily going to be the determining factor. So if the student, for example, and this does come up a lot, says, well, then what I need is I need the suite to myself, right? This 4-bedroom suite that has a kitchen, it needs to be a private kitchen. So what I'm going to need is for this to be limited for just me. Oh, and by the way, you can't charge me more than you would for the single room. That's not going to be how that's going to work if you have offered other reasonable accommodations just because they are not the student's preference. If the student wants to have, for example, to buy out a room, because that is their preference to have, you can certainly do that, but the obligation to provide something at no additional cost doesn't extend to the student's exercise of preference.
Yeah. Thanks, Jesse, for adding your wisdom. Next slide, please. We're going to talk some more about dining accommodations. That was an intersection of dining and housing, but like Jesse said, these are exploding. And you all, I bet, know just that from your experience on the ground. We thought that this might particularly come up at the change of semester after the students have been home. They've now seen the doctor for the first time in several months at their parents' insistence. And they're finally talking about, like, oh, since I went to college, I've had these issues. So maybe they're coming back with a new sense of their needs and allergies. So next slide, please. We're drawing here again from some OCR agreements, which goes to how common, frequent these issues are arising. Accessible dining options like gluten-free, allergen-free options have to be comparable in nutrition to meals available to other students. Here's the theme, comparable. If students are offered different options for lunch and dinner, then students with allergies should be offered different options for lunch and dinner. If students without disabilities are offered fruit, vegetables, grain, protein, then students without disabilities should also be offered a balanced meal. It can't be your gluten-free pizza for lunch and dinner. Students with food allergies or other dietary needs related to disability have to have an equal opportunity to participate in and or benefit from dining services as fully as students without disabilities. Really another way of saying the same thing. And the accommodation process should not be delegated to food vendors. This, we've seen in other arenas with clinics and other third parties. This is one where OCR has really seemed frustrated with universities kicking this over to food vendors who I think we would all agree are not best equipped to address accommodation requests from your students. I would note that some of these principles and the practical tips that we're going to go over may differ depending on whether you're dealing with a mandatory meal program, kind of like optional internships versus mandatory clinical programs. If this is a mandatory meal program, that scenario is most likely going to require the most accommodation from the university, unless the accommodation ends up being waiving the mandatory requirement. So let's turn to those practical tips. So I'm not going to read through all of these. What I am going to call out is that this may seem extensive and maybe even onerous, but they are all pulled from resolution agreements with the government. So I think the main takeaway here is to take these requests seriously And if you don't already have standing ways to ensure that allergen-free dining options are readily available and well managed, meaning variety of options, training on cross-contamination, that's something that you might want to put some energy into. There are two easy things that I think folks could do that seem to raise the most ire during investigation. One, I already mentioned, do not refer a student to talk to the outside food vendor for reasonable accommodation requests. And second, again, of a piece with what we've been saying, provide information on your website or whatever other materials you're providing to your students about dining for students seeking to obtain this accommodation. It seems like students are maybe having a hard time finding their way to the right contact and having that contact address the issue. So with that, we can leave behind the universe of gluten-free and housing accommodations and turn to something very top of mind at this season, which is physical access and transportation.
I mean, it sure is top of mind. 33 degrees right now in Philadelphia, anticipated to drop to the teens and to snow on Sunday. I'm definitely thinking, I don't know why I'm not in our Miami or Los Angeles office. You might be thinking maybe I should be joining a school in a southern location. But here we are in the winter weather and dealing with accessibility issues that relate to climate. Next slide, please. So, what does the law require when it comes to physical accessibility? So, the rules are different when it comes to the date of construction. So, we know that many schools have what they would alternatively refer to as either charming facilities or an aging physical plan, depending on your perspective. So, these are probably very familiar principles for you that when it comes to existing facilities, prior to the effective date, they have to be accessible when viewed in their entirety, and you can comply with the law through reassigning programs, activities, and services to accessible buildings. So, for example, a student who is a wheelchair user wants to take a class in a building that doesn't have an elevator. You can move the class, and the student can take the same class and have the class available in a different building. So, again, with the idea of registering early, is a good idea. So, offering, for example, priority registration to students who may have this need is a good thing so the student can have an opportunity to have the full selection of classes open to them. When it comes to new construction, we have to design and construct in a manner that is readily accessible to and usable by individuals with disability. And so this is probably pretty familiar. Next slide, please. But what might be a little bit less familiar is what is required when it comes to both maintenance and to transportation. Um, Institutions are obligated to maintain in working condition those features and facilities and equipment that are required to be readily accessible to and usable by persons with disabilities. So that includes things like sidewalks, walkways, parking lots, and in the law specifically does include reasonable snow removal. It is important to note that, again, specifically called out, snow should not be plowed into or on top of accessible features or components of an accessible route. So we're talking about not just sidewalks and entrances, building exits, ramps, not just stairs. So you've all seen the famous cartoon, right? The worker telling the wheelchair user, just wait for me to do the stairs and then I'll clear the ramp. And the wheelchair user says, if you clear the ramp, we can all get into the building. That cartoon is popular for a reason, right? Because it is an important way to think about accessibility. You also want to think about clearing space around any infrastructure that holds accessibility features. Most commonly, this is going to be the areas where you can activate an automatic door opener, which may be like on a metal plate or stand outside an entrance. So making sure that that is still accessible so people can access the automatic door openers. Accessible parking spaces are another issue to pay attention to. Facilities may not be aware that those larger margins cannot be used as areas to pile snow. The larger margins of an accessible parking space are actually part of the parking space and that they are necessary to permit a person to safely enter and exit their vehicle. So making sure that you're providing training for your facilities about sort of respecting the bounds of those accessible parking spaces and recognizing that their larger size does not make them open to other activities. When we talk about their access to their vehicle, we're also talking about other vehicles. Right? So this is where we talk about transportation. That could be other private vehicles, it could be public transportation, and it could also be transportation that is offered by your institution. So if there is, for example, a shuttle stop that has a curb cut and it hasn't been cleared, the shuttle can't just drop students off at a nearby location because the student with the mobility concern would not be able to navigate that. So we talked about training your facilities workers. You also want to train transportation and make sure that they're aware of what their obligations are, to make sure that people are being treated in a fair and also safe way in the event of inclement weather. Next slide, please. Staying on transportation more specifically, what are you even required to offer? Right? So, does your institution even offer any transportation? You don't actually have to offer transportation unless it is necessary to account for physical barriers on campus. So, if you have surfaces or areas that a wheelchair user could not access, then you must offer some sort of transportation option in order to enable that person to access all areas of your campus. And when I say all areas, you can't have that be so limited to say, a student can get to their classes, but nothing else. They also need to be accessing dining, student activities, and essentially being able to cross campus and use campus the way that their non-disabled peers are able to do. At the same time, if you offer more than that, if you offer additional transportation options, they have to be accessible to all students. And then finally, the accommodations, as with all things, I feel like we're still coming back to the same themes, have to be reasonable, but not necessarily preferred. So a student may really want to have curb to curb transportation, but it may be that all you offer is a single shuttle route from the entrance to main campus to the entrance of like the residential quadrangle. The student may not need to get the curb to curb transportation if the residential quadrangle is not something that is open to traffic other than pedestrian traffic. It could be that that student is offered a parking permit where they would otherwise not have the ability to get a parking permit, or priority registration to ensure that their courses are in specific campus locations that are more easily accessible. Let's take a look at a hypothetical. Next slide, please. So here we are talking about Valerie, who is a wheelchair user. She relies on college-run transit vans to access her classes. Service is canceled because of inclement weather, and Valerie asks her instructors to permit her to participate in class remotely. One of her instructors tells her this is not possible because of the nature of the course. It's an architecture studio, right? So it requires this in-person interaction and engagement that is not possible, the instructor says, for Valerie if she is at home. Valerie knows that she's already missed one studio, and if she misses another, she will earn a failing grade. And she knows she's going to be missing another because she has a specialist appointment coming up that she's going to have to miss class for. So Valerie calls Disability Services and says, I'd like to be transported to class in an emergency vehicle. How should the college respond? Jen, would you like to take a stab at this one?
Yeah, thanks, Jesse. I think that first, the college is going to have to evaluate the access to an emergency vehicle. Are they operating right now? Can you find one? Is there a driver? All those sorts of questions. And then if the answer is no, you're going to think about what else you can do. And some thoughts that come to mind is, can this class be rescheduled? Because there's inclement weather to the extent that all college-run transit vans are not operating. So maybe that is an instance where the class could be rescheduled. Could you waive the attendance policy in this instance or allow for a makeup class? So those are some things that, again, when the answer feels like no, what else can you engage in that interactive process to discuss? What do
And
you
also,
think? Yeah.
also being thoughtful about not denying something for a disability related reason that you would permit for a non-disability related reason. I've sometimes had institutions say we won't provide transportation to students with disabilities in an emergency vehicle because that's not what emergency vehicles are for. Fair. But if that's your policy, then you should also not be using emergency vehicles to transport students at night that have asked for a safety escort, or offering to transport a student who is lifting something heavy, which is something that oftentimes happens. So if you do allow this kind of accommodation for students without disabilities, the fact that it is for disability should not be a dispositive factor, because that in itself could be a discriminatory issue.
Let me jump on that because something else that comes up is documentation. And Similarly, I think it's a trap that, institutions fall into of asking for documentation of disability for an accommodation that is something that is already offered within the realm of their services. And that, again, could be discriminatory.
That is a great point.
All
We're
right.
going to move next slide onto academic accommodation change requests, and I'm going to turn that back over to you again, Jen.
Yeah, we're in the back stretch here. And this really should, next slide, please, should be a refresher. Let me give you this credit code, which is 93155. Again, credit code 93111. Sorry, 93155. Okay, academic accommodations. I bet that is your bread and butter. We're talking about them because sometimes those requests, you've granted a request, but now the student's seeking a change in their accommodation. Maybe they've seen what some other students are getting access to and think that's right for them. Maybe their grades came back and they think, oh, I need an accommodation that they hadn't asked for before. So again, this turn of the semester may be a time where this is coming up. Some things to keep in mind. Accommodations are not retroactive, so we're only going to be able to look forward with that student. They could depend on the nature of the class. So the fact that an accommodation was granted first semester for a particular class doesn't necessarily mean that it's a reasonable accommodation for a class that the student is in this semester. And again, that major point, it has to be reasonable and not necessarily preferred. So if they've gone home and they've heard what their friends are doing, and it's like, oh, that would really work better, or I like that more. It feels easier. That doesn't necessarily mean that's what an obligation on the university if the other alternative or existing accommodation was already appropriate to address the disability. Next slide, please. All right, so this is a ripped from the headlines example. It's well, perhaps not surprising. It's a California university. We'll say that. So first semester, Tim had an accommodation to adjusted. Tim had an accommodation to record classes, which were mostly large lectures for first year students. Second semester, he registers for an upper level course. The syllabus has a no recording policy. And when Tim gives the professor his accommodation verification letter, she says she can't accept it. She explains that she adopted her policy because the class discusses sensitive and controversial subject matters, and she believes that recording will chill speech. Tim demands that the faculty member be required to permit him to record. So the real life facts are that this professor, the class discusses very sensitive material, and she, after becoming frustrated with students with accommodations to record, put it in her syllabus that if you recorded the class, whether or not you had a granted accommodation to record, you would fail. Um, and the university actually did ultimately go along with that and adopted language that for this class, it would be a fundamental alteration to allow recording. Now, I don't know of a judicial opinion that finds that that a blanket no recording policy is acceptable, compliant. I think a blanket ban is probably going to be problematic. You generally need to have an individualized inquiry. But it is also possible that a different accommodation is more appropriate for this class. So in this case, what the professor has allowed is for peer student note taking. And in many ways that makes sense. They don't want recording circulating that could harm a student's future employment opportunities based on things being said in class, and it's still allowing a student to record in a different format what's being said in class. So I think that wraps up academic accommodation and leads us into our final segment on responding to parent-family inquiries, which I'll turn to Jessie.
So we're thinking about the spring semester. Students have gone home for winter break. They've gotten their grades, which they are probably sharing with their parents. They may be sharing more about their first semester and how it went when they were at home with their families. And you may get some parent or family inquiries and be trying to decide how to respond. Next slide, please. The first way to think about this is really as a privacy issue. And what is it that you can or cannot disclose to a inquiring parent or relative? Generally, you can't disclose records to parents without a student's consent, and that's because of FERPA. There may be other state and local privacy laws, as well as internal privacy policies and practices that you may have either in practice or that you've published and made available to your students and affiliates. There's plenty of exceptions to FERPA. There's the health and safety exception that enables you to have contact with families. If the student is claimed as a dependent, that also opens the opportunity to share education records. And then you can also share information with families about drug and alcohol violations. So there's plenty of exceptions to FERPA that do enable you to disclose information about students to families without the student's consent. Um, Also, importantly, there's nothing in FERPA that prohibits a school official from sharing information with parents that is based off of that person's personal knowledge or observation. So it's not the same as sharing an education record or sharing information that is only in an education record. Someone who observes something that is concerning or where they feel that there is some sort of intervention that may be needed, sharing that personal experience or observation is permissible. So to the extent that you have parents contacting faculty to ask questions, there's nothing that would stop a faculty member from sharing their personal impressions that are not coextensive with education records. I always encourage people to take a look when it comes to the joint guidance on the application of FERPA and HIPAA, because this is an area that people very frequently misunderstand. So that was a 2019 revision date, and that was a joint guidance by Ed and HHS. It's still available. I strongly recommend taking a look at it because this is an area where there's a lot of misunderstanding. Next slide, please. So those are the sort of legal guide rails and parameters, but oftentimes it's really not so much a privacy issue so much as it is what are we doing to help support students in their sort of journeys of independence, and of self-reliance and all of the other things that we want them to learn when they are in college. Even if we can share information with a parent, is that what's going to be helpful? Is that really what the parent wants? Is that what the student wants? Is that supporting the student's development? So some practical tips and things to think about are being available to receive information. Is this something that you can always do without violating a student's privacy rights? So taking information that someone provides to you and considering that in how you support or treat the student, very valuable. Preparing parents for the change in access that they may have is important as well. So we talk a lot about in this presentation, preparing students for change, preparing students for transition. Parents and families may also need some of that support and offering, for example, sessions during move-in day or orientation, or move back day after winter break, having a table set up with someone from your disability services office to answer questions. Those kinds of touch points can go a really long way towards building trust with parents and families. And then finally, working to support students' resilience and independence in many other ways is also a very helpful thing. I have my little bear icon here. You might be thinking, why is that there? There's like the whole mama bear online, you need a power of attorney situation that many of you may have encountered, and these sort of increase in requests to institutions to disclose information where it would not be permitted by FERPA or to essentially cede decision-making authority to the parent or guardian. And how colleges are sort of struggling with that at the moment. So let's move to the next slide and talk about our last hypothetical. So this is a very prototypical situation that many of you may have encountered. If you have not, you probably will at some point. While moving her son Taylor back into his residence hall after winter break, Taylor's mother asked to meet with the head of disability services. She and Taylor come to the meeting together and she presents what she calls a power of attorney form to disability services, right? It's signed by Taylor. She hands it over and says, that disability services must only communicate with Taylor in writing, must copy Taylor's mother on all communications to Taylor, and must not implement any accommodations unless approved by both her and Taylor. So how should the college respond to Taylor's mother? So again, these power of attorney documents are becoming very prevalent in a way that they weren't even just, 2 years ago. So if you haven't encountered any, I think it very likely you will. The power of attorney documents very rarely do what the parent or family thinks that they do. They very rarely address FERPA issues in a way that is legally adequate. Schools are not obligated to receive these documents and interpret them in ways that the parent would like them to do, particularly if it compromises the rights of the student. Power of attorneys typically will be things like if the student is incapacitated and incapable of decision making. That is not what we're talking about when we're talking about academic accommodations. And just what the parent is asking here in the situation, that the parent, they have approval over the student's academic accommodations. In this situation, treating the parent with respect is important, right? You don't want to treat someone ever like they are not important to you, especially here when we know this comes from a position of care and love for their student. But these power of attorney documents, if you're presented with one, we can certainly talk about it on a one-to-one level. But they really don't mean really very much of anything. And it may go a long way for you to prepare for the receipt of such documents, maybe by having something on your website or like an FAQ that addresses this topic, and having your FERPA waiver information very available, including the FAQs about FERPA, sort of the standard ones that we see. When can information be disclosed? Can my student revoke permission for me to see information? Does FERPA, if I have a FERPA waiver on file, does it obligate a faculty member to send me my students' grades? Those kinds of commonly asked questions that come up. Really having that documentation prepared and available, for example, during move-in weekend and on your website, is a good idea to have. Unlike technical standards, I think there's a lot of really good FERPA FAQs out there that you can borrow from as well. So if you're looking for peer or comparator institutions, there is a lot out there. Jenna, looks like you were going to jump in.
No, I'm good.
Oh, sorry. That actually does bring us to the end of our program. We do have a little bit of time for Q&A. I'm going to check back in the Q&A section and see if we have anything that hasn't been answered. So we previously had a question about personal care attendance, and the advice or the answer that was provided there was about how that may really vary depending on the context, but that colleges don't have an obligation to coordinate or pay for personal care attendant duties. The question was, well, what about a student study abroad trip? The same sort of general principles will pertain there, where we're looking at fundamental alteration. But if the question is something like, do we have to pay for airfare for the PCA? The answer to that would be no. If you have a specific question about that, because this seems somewhat discrete, please feel free to email either me or Jen, and we would be happy to walk you through that analysis. And then our last question says this may
Yeah.
not be on topic, but I think it is on topic. What about the use of medical marijuana in clinical environments? Jen, do you want to take a crack at that one?
Yeah, well, I've been thinking a little bit about it because I think it's tricky. I think there's a couple issues at play, like even jurisdictional questions of like if you're in DC, maybe there's rules in Maryland and Virginia, and you're dealing with different rules in different places. But the way the question was framed also gave me pause, like how much effort should we put in? And in some ways, it's always going to be the same amount of effort. It just may be more or less complicated. If none of the clinics are going to have this accommodation available, and you know that from prior experience, etc., that may shorten the inquiry. But I would say I feel as though in terms of effort, you're always kind of making the same amount of effort to find a solution and just whether or not those solutions are available. What do you think, Jesse?
I agree. And I think that your first point about jurisdictional issues, it can't be overstated how important that is. Medical marijuana is an extremely fast-moving target, and depending on where you are, there's fundamentally going to be very different options available. That may be an issue for students in clinical placements because we know that the physical placement is always a contentious issue. Students don't want to travel or they want a particular state or something like that for where they will be. So thinking about your expectations that you set up front about where students may be assigned to clinicals and what they may need to do is important. So some have like radius expectations. You may have to relocate for periods of time. That changes depending on the nature of the program. Medical school is different than like an MA in nursing. But that is an important thing to think about as
We're
well.
at time, but I want to piggyback on Jesse's pet issue, which is the program standards. This could be a place where it's like you have to be clear-headed and capable of decision making. And if you know that, medical marijuana use is not going to be an option in any of your clinical placements, maybe that's something to think about.
All right, we are at time. Thank you everyone so much for attending today. If you have any follow-up questions, please don't hesitate to email or call one of us. We'd be very happy to talk to you. We hope that you have a undeservedly short but hopefully easy winter break and a good start to the spring term. Thank you so much.
Thanks all.